I'm trying. Once I start the live stream, I think you can. I'm waiting
What's
for
that?
it to load. I said once the live stream commences, I think you can start. I'm waiting for it to load. I'm just waiting.
Okay. It says that it is being sent to YouTube.
Sir?
I said I've gotten a notice that the meeting is being live streamed.
Okay. So just waiting just a few more seconds. I'm waiting for it to load.
I guess we can allow everybody.
Okay, I think you can allow everybody in at this point.
They are good to go.
I'm good to go.
Okay, no, I don't mean you as in okay. Okay, and that means you let everyone.
Is the moderator good?
Is the moderator good to go? I think ICLE is in.
Labake,
Chairman is
go.
Labake, you can't be silent.
I'm good to go. I'm good to go, sir.
With the co-hosting capabilities, right?
Yes, sir.
The co-host.
Okay. And do we need to give Ebenezer a co-hosting capabilities? Is Ebenezer here?
Ebenezer who?
Ebenezer Adeyemi.
Okay, come in. Let me check for that.
Which other speaker is in this co-host?
Ebenezer is not in the waiting room.
Okay, you should be going through the waiting room. Go through the waiting room to look for other speakers.
Okay. No problem.
Labake,
I'm with you. I'm with you, sir. Yes, sir.
Don't be with me. Be in the waiting room looking for additional speakers so that we can let the speakers in. Because once we open it up to everyone, the room will fill up immediately. I see Justice Okamin, my Lord is in.
Yeah, my Lord. So go and look for our June, Mrs. Joanna.
All right,
so
sir.
We're waiting for our June and Mrs. Joanna right now.
So I think we just let everybody in. We have 68 people waiting. And it's 4:03. Yes, Arjun, are you in?
Yes, she's here. She's here already.
Arjun has to device. Yes.
Arjun is in.
Is she a speaker so I can make her a co-host?
Yes, he's a speaker.
Okay.
And then Mrs. Joanna. Timmy talk about Joanna.
No.
She's
Mrs. Joanna is not in.
She's not here yet.
She's not in yet. So we admit everybody now.
Okay.
Okay, so it's 4:03, I think. The moderator ready?
Yes, I am, sir.
Okay. Everybody's coming in then. Before handing over to the moderator for today, I'd like to just welcome everyone. Good afternoon and welcome to a yearly session organized by the Nigerian Bar Association Garki Branch Continuing Legal Education Committee. This session is going to be very interesting, and I'm sure that it's going to be very interesting, very engaging, and very practical. We have very seasoned experts and professionals in the house. I'm really excited to be a part of this discussion. And my name is Folari. I'm the chairperson of the Continuing Legal Education Committee, the NBA Garki Branch. I'd like to welcome us all. My Lord, you are very welcome. Yeah. I'll hand over to our moderator for today. Her name is Omolabake Oku. So Labake, over to you. I would encourage everyone, please, let's make it very interesting. So over to you, Labake.
All right. I believe you can all hear me. Good evening, everyone, and welcome to our webinar hosted by the Nigerian Bar Association Garki branch in collaboration with All Arbitrate International. We are excited to have you join us for this important conversation on the topic, technology, artificial intelligence, and dispute resolution, leveraging virtual tools for professional growth. My name is Omolabake Ohu. I'm a lawyer, and I'll be your moderator this evening. I also have here with me Esther Asumbe, who will be my co-moderator this evening. Good evening, Esther. Esther, can you hear me? I need you to acknowledge. Okay, once she's able to unmute her mic, she would acknowledge. All right, so moving forward, we are honored to have some amazing speakers here with us who bring rich experience and insights. So we are particularly honored to have in our midst the distinguished chairman of the NBA Garki branch, in person of Mr. Anthony Bamidele Ojo, whose leadership is very pivotal to opening this discussion. So he's one of the forward-thinking and futuristic NBA chairmen in Nigeria. And we are honored to have you here, sir. You're welcome, sir. Also to the ESCOs, the former chairman of the NBA Abuja branch, the senior members of the bar. We are honored to have you all here. You're welcome. Also to all our panelists and participants joining from different parts of the country and beyond, thank you for making the time to be here. Thank you so much. Really appreciate. Your engagement is what makes platforms like this truly impactful. So before we begin, just a quick note. This is a safe, respectful space, and we'll keep the discussion structured on the topic. All right, so on our objective, part of our objective today is to explore how digital platforms are breaking barriers, allowing professionals to arbitrate, mediate, and manage cases virtually, regardless of borders. As we go along, we'll be gaining insight on emerging opportunities for lawyers who are ready to embrace these tools. So by the end of this webinar, participants would be able to understand the business side of ADR beyond the myth. Also, participants will be equipped with the practical knowledge and tools to gain access into a successful practice of arbitration. And lastly, participants will learn their roles in attracting investment that would increase their clientele and income. So I'll hand over the microphone to my co-moderator, Esther Asumbe, to introduce our speakers. Esther, you have the floor.
Thank you, Omolabake. I'm grateful.
You're
I was
welcome.
unable to get my mic earlier. And we have an interesting lineup of speakers today. After I read their citation, they will just acknowledge to the House. So first on the list is my Lord, Honorable Justice Adeniyi Pokornun. Honorable Justice Adeniyi Pokornun is a distinguished judge of the High Court of Lagos State. He is widely respected for his expertise in civil and commercial adjudication. Honorable Justice Adeniyi has an unwavering commitment to justice and judicial integrity. He has delivered numerous well-reasoned judgments that reflect deep legal insight. His service exemplifies excellence and a dedication to upholding the rule of law. Ladies and gentlemen, Honorable Justice Adeniyi Pokornun. So I could just signify to the House. All right. Moving on, I would move on to read the citation of Mr. Arjun Shetri. Mr. Arjun is the managing partner of Annex Law Limited. It's a legal advisory firm that supports startup, SMEs, and global businesses. Mr. Arjun is a qualified lawyer and holds an MBA from the UK. He brings over a decade of experience across litigation, corporate law, and cross-border advisory. His work blends legal insight with business strategy, helping leaders make clear and high impact decisions. Mr. Arjun, it's a pleasure to have you. Would you signify to the house? Would you say hello? Mr. Arjun. Okay, Mr. Adeni, you just responded to everyone in the chat. So, Mr. Arjun.
My Lord,
My Lord, Adeni Okan. He just responded in the chat. Thirdly, I would move on to introduce Barrister Folari Aluko. Barrister Folari is a Nigerian legal practitioner and a partner at Truman Rockwood Solicitors. He specializes in intellectual property law, technology and fintech law. He's a former chairman of the Nigerian Bar Association, Abuja branch. He's also a director at the Intellectual Property Institute Nigeria and chairman of the Board of Trustees for the Intellectual Property Lawyers Association Nigeria. With expertise in finance and capital markets, he frequently serves as a legal advisor for companies in the creative and technology industries. Mr. Folari, would you say hello?
hello everyone. Thank you very much.
So I just saw that Mr. Arjun was just able to rejoin the chat. Moving on, I would introduce Mr. Kayode Adeniji. Mr. Kayode Adeniji is the senior partner at Laurels LP and Arbitrators. He's the founder of All Arbitrates. His legal arguments in the landmark case of Megawatts Nigeria Limited versus Incorporated Trustees of Bagada Phase 2 Residents Association produced the groundbreaking judgment of the Federal High Court on the rights to freedom of association. Mr. Kayode Adeniji played a major role as a legal advisor and representative of a major shareholder in the Econet and Airtel International Arbitration, one of the biggest and most complex international commercial arbitrations in Africa. Mr. Kayode, it's a pleasure to have you. Would you say hello?
Thank you for having me, Esther.
Finally, I would introduce Miss Temitope Johanna. Miss Bemisola Temitope Johanna is the head of licensing, legal, and regulatory affairs at Cheaper Cash, where she navigates complex regulatory landscapes to enable business expansion. With over a decade of experience, she is known as the solutionist for her proficiency in driving growth in high-growth environments. Her extensive expertise supports Cheaper Cash in its strategy to operate within legal boundaries while pursuing aggressive growth in the fintech space. It's a pleasure to have you, ma'am. Would you please say hello if you're on the chat? Those will be our speakers for today. Back to you, Molade.
All right, thank you very much, Miss Asumbi. Okay, so without wasting much of our time, we'll now get right into our first session. And joining me on this first segment is my Lord Honorable Justice Adeni Okanu. And our main focus will be on institutionalization and procedural transformation. My Lord, are you with me, sir?
Thank you very much. Yes, I apologize. I couldn't make my voice heard earlier on as I couldn't unmute. But since I'm now a co-host, thank you so much. Thank the organizers, especially for this opportunity to share my thoughts. By way of protocol, I want to greet my distinguished learned brothers, honorable judges of the High Courts here present. I greet the chairman of the MBA Garki branch, Mr. Anthony Bamidele Ojo. I also greet the organizers, that's the All Arbitrates, and also the MBA branch of Garki. Now, the topic at hand is technology, AI, and the future of dispute resolution. And very shortly, I'll be looking at the judicial perspective on innovation, efficiency, and access to justice. So I will be sharing some of my reflection on how technology has assisted me in resolving disputes in the Lagos State High Courts, and also connect some of my experience with some of my observation on our profession's attitude to ADR. So as a sitting judge, I've had the privilege of witnessing firsthand how technology has transformed the daily administration of justice. And these reflections are both practical and aspirational, drawn from my experience on the bench and observation of the evolving attitude of lawyers towards technology and ADR. So I'll take it from the realm of technology and litigation. In the area of litigation, technology has immensely contributed to a paradigm shift in the mode of court proceedings and justice delivery in our courts. For instance, the Chief Justice of Nigeria recently emphasized in one of our papers, which is a special public lecture delivered at the University of Lagos, titled Justice in the Digital and economic barriers that distance Nigerians from justice system. Indeed, digital technologies such as e-filing systems, digital case management platforms, and virtual courtrooms are being rapidly adopted in Nigeria's judicial process for effective case management. Nonetheless, the rising volume of cases in our courts has continued to slow the pace of justice. Therefore, leveraging advanced technology such as artificial intelligence, blockchain for evidence tracking, and automated case scheduling will enhance the capacity of our courts to decide the cases before them expeditiously. It needs to be said that deliberate and strategic integration of such advanced technology can streamline our judicial process by eliminating bottlenecks and delay. This will ultimately improve accessibility of citizens and enhance justice delivery. And I cannot agree less with the Honorable Chief Justice of Nigeria. And that is why in Lagos State, for instance, digitizing our judiciary and revolutionizing the concept of justice delivery started with the evolution of the Lagos State Judiciary Information System, which is known as JIS, introduced in October 2013, through to the contemporary innovations such as the Court Management Information System, which is Lagos COMIS, which is more operational at the Magistrates Court, and then the Bail Information Management System, which is BIMS, and Offenders Biometric Scheme, and other emerging artificial intelligence assisted tools. These innovations have greatly aided justice delivery in Lagos State. I've referred for further reading the paper of my learned brother, Ari Ushudi, titled Digitization of Justice System in Lagos State, The Journey So Far, which is a paper presented at the Lagos State Judges Retreat in Brighton, UK. I particularly refer to pages 2 and 4 thereof. So some of the areas where technology has assisted justice delivery, firstly is e-filing and case management, which now makes it possible to initiate and track cases electronically, thereby avoiding that bottlenecks and delay of paper-based filing. Then you have virtual hearing, which was introduced during the pandemic. And this has greatly assisted access to justice. And I say that for sure because, for instance, in my court, most of matrimonial matters, let me say 40% of them, are usually had via virtual means. And the court has increased from 2 licenses to 21 right now. And I've had instances whereby not just for litigants that are outside Nigeria, I have instances of litigants that are bedridden in hospital and cannot make it to court. So virtual hearing has assisted access to justice and ensure efficiency, speedy resolution of disputes. Then we have digital evidence and transcription tools. These have enhanced trial management by reducing these disputes over what was said or creating accurate and real-time records of proceedings. So these are some of the simple yet effective steps that have been taken by the Lagos State Judiciary and as well as other judiciary in Nigeria, even up to the very simple step of publishing cost lists online. And for me, in our courts, the week before, we send our cost list to the JIS, and it's even circulated among lawyers. So it's an effective tool to ensure that justice delivery is brought to fore and it removes delay and saves costs. I'll now look at AI and legal practice in Nigeria generally. And I will now say that artificial intelligence is rapidly transforming legal practice worldwide, and Nigeria is gradually embracing its potential. AI refers to computer systems capable of performing tasks that normally require human intelligence, such as reasoning, learning, document review, and prediction. Now, AI is not far-fetched. For instance, I'm sure for most of us as lawyers, when you want to draft a motion, if it's a motion you've worked on before, for instance, motion for interlocutory injunction, you don't go ahead drafting it all over again. If you have a draft in your system, what you simply do is that you go to your search button or you go to where you save the documents and you bring it out from there. That itself is artificial intelligence. And it is when you now apply technology to it to ensure that you perform that task, which normally requires your human intelligence, then that is artificial intelligence. And as the name bears, artificial intelligence, it shows that it is based on the intelligence you have imputed therein. That is what the AI will give back to you. So whatever prompt you impute therein, it goes in there and gives you output, not just from what you've imputed, but based on what every other person has imputed into such AI platform. So what are the key areas of AI application, especially in legal practice? Firstly, we have in the area of legal research and drafting, we have tools like ChatGPT and Lexis Plus, which is AI enabled. It enables faster legal research, summarization of cases, and even automated drafting of pleadings and contracts. And even within our shores, you have Law Pavilion and the Nigeria Law Reports, which have equally been incorporating chatbots. Chatbots are robots that you can input your search in, and then it gives you answers based on the prompt you input therein. So it's a species of AI which helps users to have seamless and faster legal research. Then secondly, in the aspect of document review and due diligence, AI would also assist you as legal practitioners to analyze large volumes of documents in litigation or commercial transaction. So this will improve speed and also reduce error. It also helps in case prediction and analytics. AI can analyze judicial trends to predict likely outcome, a valuable tool for case assessments and strategy. And platforms like Law Pavilion is really upgrading their platforms in this instance. And it also assists in client management and automation. So chatbots and automated platforms enhance client communication. You can use to appoint and schedule your meetings and also assist you in efficient delivery of your routine legal services. You can also use AI in e-discovery and evidence analysis. It helps to organize and analyze your electronic evidence, especially when you are dealing with commercial or fraud-related matters. So these are some of the areas where AI would assist to reshape legal practice by streamlining research, enhancing document review, improving case strategy through predictive analytics. And for some of the very cogent points, I've referred to the paper of Olumide Bawala, which is cybersecurity in an AI-driven justice system, the bar, the bench, and ethical concern, which is a keynote paper presented at the Lagos State Judiciary 2025 and 2026 Legal Year Summit. So this also tells us that even from the judiciary are making steps to ensure that we key into AI and every recent technology that can help to enhance justice delivery. So while our jurisdiction is still developing regulatory frameworks for AI, there is no denying its transformative capacity to redefine how we think, analyze, and deliver justice. And I'll now look at the attitude of lawyers to AI, because I've noticed that the same attitude we had to ADR, the same we have transferred, or we may transfer to artificial intelligence if care is not taken. Because you have situations where even before we started talking about AI, lawyers will tell you that they don't have emails. They are not email compliant in order to receive hearing notices. So it's as bad as that. So our attitude must change in order to embrace AI and also to apply it to alternative dispute resolution. Why some see it as a threat, some see it that it threatens their purse, which is their income. So this mindset as to threat to adversarial advocacy is understandable because that's the system which we practice. But ADR is not a threat to our profession, it is a complement to it. And in many cases, it is more efficient and a satisfactory path to justice for our clients. So I want to draw a common trend amongst ADR, AI, and technology. Here, I've come to realize that the same resistance that lawyers show towards ADR often extends to technology. And that is why we both require a shift in mindsets from the familiar adversarial method to approaches that emphasizes speed, collaboration, and efficiency. So just as some hesitate to trust a mediator's process, many will hesitate to rely on virtual hearings or digital platforms. So the resistance is rooted in fear of losing control, and an attachment to tradition. But whether we like it or not, the world is moving fast and moving forward. Clients are demanding quicker, more affordable resolution. And that is why you see some of them would prefer to report their cases first to the police station because they believe that they can get quicker resolution. So there must be an attitudinal change from the bar and the bench. So ADR and technology are not threats to our profession. They are essential tools for meeting modern demands. So we must overcome this resistance and also find ourselves, in order to find ourselves more relevant, productive, and prepared to meet the future. Because whether we like it or not, if you don't embrace ADR, AI, and technology that comes with it, non-lawyers will approach it. And that is my fear. If non-lawyers take on it, they will turn into a commercial venture and it will bastardize the system. So the earlier we embrace it, the better for the system, the better for us. So the pushback against ADR mirrors the general existence among the legal industry to embrace innovations such as AI and virtual legal technologies. Just as ADR disrupts the conventional courtroom-focused mentality, AI and online platforms disrupt traditional concepts of legal expertise, hierarchy, and manual processes. But in both instances, change is not a matter of substituting lawyers. It is a matter of transforming how we, as lawyers and as players in justice sector, provide value. So what we eventually do is to enhance value delivery when you apply ADR and AI to dispute resolution. Attorneys who surmount this opposition and open themselves up to these tools set themselves up for more relevance, productivity, and professional developments in an evolving legal environment. So I want to encourage especially our young lawyers. Yes, you are the Gen Zs, you have the knowledge. Like the chairman of session said at the Legal Years Summit of the Lagos State Judiciary. He said for those that are above 40, 45, 50, you need your grandchildren to teach you AI. But for those that are young now, below 40, you have that advantage. So you don't need a grandchild to teach you. You can teach yourself. You can get the relevant training, improve on yourself. So I become relevant, productive, and develop thereby. So what is the way forward? And I've identified some of the things that we need to do. Number one is what MBA Garki branch is doing, and I thank the chairman, Mr. Anthony Bandilo Ojo, is to reorientate through the bar and the bench. So there must be a cultural shift, and the MBA must lead this crusade in training and retraining. So, and I thank God that this very webinar is CPD based. So that's a very good one. So continuing professional development should prioritize not just black letter law, but also training on technology, ADR, and modern day legal practice tools. Secondly is the judicial policy and enforcement. The court itself should continue to implement and enforce rules that encourage the use of ADR and technology. At this stage, adoption should not be optional. It should be systemic, inbuilt, should be built into our system. Around the world, courts are not only using AI tools, they are also starting to set rules for how these tools should be used in the justice system. And their experiences offer important lessons for us in Nigeria as we navigate the future of legal technology. For instance, in a recent English case of VP Evans and the Commissioner for HMRC, citation is 2025 UK FTT, that's the tribunal, the tax tribunal, 112 TC. I've given the citation. A judge openly stated that he used Microsoft Copilot to help draft summaries for legal documents. However, he made it clear that all final decisions, legal reasoning, and judgments were entirely his own. This is a model example for how judges can foster adoption of AI. And I've added that, however, it is worthy of note that earlier on the 15th day of April 2025, the Courts and Tribunals Judiciary published Artificial Intelligence Judicial Guidance. And you can find that at the judiciary.uk/guidance. Now, the guidance is to the effect that Judicial office holders can apply AI. So it gives guidance on how to apply AI. The stated aim of the guidance was to assist judicial office holders in relation to the use of AI. It emphasizes that any use of AI by or on behalf of judiciary must be consistent with the judiciary's overarching obligation to protect the integrity of administration of justice. The guidance mandated the use of a private AI tool, Microsoft's Copilot Chat, which is available to judicial office holders through their platform, eJudiciary. So as long as judicial office holders are logged into their eJudiciary accounts, the data can enter into Copilot. Sorry, the data entered into Copilot remains secure and private. Unlike other large language models, that's LLM, it is not made public. Now, I say this because some of the concern for application in applying AI to the judicial system is that by the time you put in some facts, you put in some of these documents you want to summarize, it makes it public and accessible. But when, in terms of this Copilot, it is limited to just the judiciary and it's not made public. So it's a very unique large language model, LLM. In Nigeria, I must say this, a somewhat similar initiative is being adopted by Apex Court as announced by my Lord, the Chief Justice of Nigeria in his Lordship's legal year speech. And I've made reference to the speech by my Lord, the Honorable Justice Kudirat M. Okeke-Ekun, GCON, Chief Justice of Nigeria, at the special session of Supreme Court of Nigeria, marking the commencement of the 2025-2026 legal year on Monday, September 29th, 2025. So same is available at supremecourt.gov.ng/speech. Now, in our speech, the Honorable CJN noted that the judiciary is currently undergoing a transformative digital revolution with progressive adoption of Nigerian Case Management System, NCMS. So it's an official nationwide platform meticulously developed under designing guidance of the NJC. So this sophisticated system is designed to digitize the entire spectrum of case handling, thereby facilitating the seamless and instantaneous transmission of files from the litigation department of a particular state, for instance, to the chief judge for judicial assignments to the appropriate judges. It strongly suggested that the NCMS, this is my own suggestion, should be mirrored, or should rather mirror the UK's e-judiciary in terms of secure and private LLM, that's large language models for judges only. So this will protect the integrity of administration of justice, as well as ensure the protection of data privacy rights of court users. Because in terms of the judiciary in the UK, judges can put in their documents for sake of some summaries, and that would aid effective justice delivery. But when you put in those documents in public LLM, like probably ChatGPT, you may put in Lagos at this very moment, and tonight somebody will have access to it in Garki, Abuja. So this would be injurious to data privacy. And so it is strongly suggested that our own NCMS, which is still in the works, should mirror the UK's e-judiciary in that regard. And then C, client-driven innovation. So as lawyers, we must not forget that we serve the clients. So today's client demands results that are faster and more cost-effective. So lawyers who cling to outdated models may retain their pride, but lose their clients ultimately. And I've also added D, integration of technology with ADR. So the future lies in online dispute resolution. And I want to acknowledge the the efforts of all arbitrates in that regard in order to ensure that from filing to enforcement or from filing to award, everything goes on seamlessly by virtue of technology, which is online dispute resolution. And I must also add that the Lagos Multi-Door Courthouse is also well positioned to pioneer this transformation. In conclusion, respective colleagues, my experience in Lagos High Court of Lagos State has shown me that technology works. It saves time, reduces costs, and enhances access to justice. But technology is only a tool. Its full potential is unlocked only when we shed the mindsets that also resists ADR. The future of law in Lagos State and indeed in Nigeria is one where ADR and technology converge. We must embrace this convergence, not reluctantly, but with vision and leadership. For if we do not lead this change, we will be led behind by it. I thank you all for your kind attention.
Thank you very much, my lord, for that
Thank you.
engaging and insightful conversation. I mean, in fact, it's like we're in sync. If I could even think of a question, my lord has already answered it. Shows that you're really prepared for us, my lord. Thank you very, very much. You indeed set the stage so powerfully. And I believe that we all agree that one thing we've learned today from my lord is that rather than seeing AI as a threat to our profession, we should see it as a complement to our profession instead. So thank you very, very much, my lord. Really appreciate it. Okay, so moving on. If anyone have any question for my lord, you can please drop in the chat box and I'll address them shortly. Okay, so before, without wasting any more of our time, we'll now move on to our second panel session, which will focus on global trends and specialization. So join us for this session are distinguished experts, Mr. Arjun Shetri and Mr. Folarin Aluko. You're welcome, gentlemen, and thank you for being here with us. Can you kindly unmute and acknowledge? Mr. Arjun and Mr. Folarin, are you with us?
Thank you very much.
Hi,
Yes.
thank you for having me here.
Thank you very much for being here. Okay, so let us get right into it. I'll be starting with Mr. Arjun Shetri. All right, so sir, you're an Indian based in the UK.
That's correct.
Thank you very much. So from your perspective in the UK and India, can you share your thoughts on how technology has reshaped ADR, that's alternative dispute resolution, particularly for lawyers outside traditional network, as lawyers who don't practice law in the conventional way?
Okay, so thanks for the question. If I compare UK's and India's legal ADR system, UK's ADR system is far more mature and integrated into the judicial process. The UK emphasizes early settlement through court-backed mediation and well-established institutions, while India is still in the younger phase, but has made significant progress. I believe both jurisdictions aim to reduce court backlogs, promote party autonomy, and encourage faster, confidential dispute resolution. I hope I have answered your question.
Oh, all right. Thank you very much, Mr. Arjun. Thank you very much for that thoughtful response, that practical breakdown. All right, I'll be moving on to Mr. Folarin Aluko for my next question. Mr. Folarin Aluko, are you with me?
Yes,
can you hear me, sir?
Yes, I can. Okay.
All right, thank you very much. Okay. All right, so Mr. Aluko, you specialize in intellectual property, a field with increasing cross-border disputes, if I'm not mistaken. Are you with me, sir?
Yes, that's correct. That's
All right.
correct.
So,
Yeah.
all right. So, drawing from what Mr. Jonas earlier said, how do you see AI and virtual hearing changing your area of practice?
I mean, that's a very loaded question. I should say a big thank you to my Lord, laying a very solid foundation for what should be, I think, a robust and practical conversation. So I would like to tweak the question a little because I think that if one of the things I picked from my Lord's intervention was that there is a real challenge when it comes to access to justice in Nigeria. You know, AI is a tool that can actually bring or provide justice to the millions of Nigerians who are looking for justice every day. You know, and this is true in IP as it is true in almost every area of legal practice. You know, I also do some work in criminal justice space, so I can speak to this very easily. So I would like to tweak the question a little to highlight or to demonstrate the fact that there is a huge justice gap or a huge access to justice gap in Nigeria, particularly within the intellectual property space, since you narrowed down, you know, the question to that area. And so what this means is that there are many opportunities for lawyers, actually, because our work, one of our primary roles is to serve as dispute resolution agents, you know, and so it means that there are huge opportunities for lawyers in that space. So the question is, if there are huge opportunities, and so if there's a high supply in terms of disputes, and there is a high demand from the market, the question is, you know, why have lawyers taken advantage of these opportunities? And so I would say that, you know, tech has done a lot to bridge the gap. I recall I had the opportunity of, and I always tell the story, demonstrate the importance of, or the impact that tech can have, you know, on the justice sector. We had a discussion series many years ago in 2019, and my Lord Justice Echo of the Federal High Court, representing the Chief Judge of the Federal High Court, he made a comment. It was on, you know, digital practice and things like that. Something like that was the theme of that series. And my Lord made a comment and said, in about 10 years or maybe 20 years, we'll have robot judges, we'll have proceedings, electronic proceedings, you know, and we all laughed about it. You know, but in less than, that was October 2019, in about 6 months' time, you know, NIC had commenced hearings via Zoom. You know, and the whole world, of course, because of COVID, the adoption of technology was accelerated. So I would say that tech has done a lot in terms of fast tracking access to justice for a lot of people. Of course, we started having this conversation during COVID, and that has changed the fortunes of many people, including Zoom, the platform that we're on. In fact, another company that had the name Zoom also benefited from, and I'm saying that as an IT, just like an IP lawyer, benefited from Zoom, this company's, you know, sudden boost in terms of usage and, you know, this virtual hearing technology. So I would say that AI has done a lot, and tech has done a lot to accelerate access to justice. I will say this, today I wear a number of caps in this session because I'm the chairperson of the MBA Garki Branch CLE committee, and I'm also the founder of the Intellectual Property Lawyers Association Nigeria. And we're very fortunate at the IPLAN now to have a platform that we call the IPLAN Clinic that provides access to pro bono legal services to people in the creative industry across Africa. So we are able to do that because of technology. Technology makes it easy, makes it possible for us to sit down in, you know, different parts of the world. And the clinic has, I think we have about 300 people who are subscribed at the last check. You know, we have students who are learning. You know, it provides all manner of opportunities to a wide variety of people. So I would say that technology has done a lot to democratize access to justice. You know, but the question now is, what do we do as lawyers? You know, how do we plug in? I think one of the ways to plug in is to find specializations. I don't want to jump the gun, but I think you're going there. But the key really is to specialize, because there's no such thing as just as we used to say this person is a litigation lawyer. There's litigation in every area of practice. There's litigation in IP, there's litigation in corporate commercial law, there's litigation in finance, litigation in real estate, as well as regulatory and other forms of legal practice. So specialization is the key, I think, to the future of dispute resolution, particularly with powered by tech.
Thank you very much, Mr. Aluko. That was really, really insightful. Thank you very much. Okay, so moving on, I'll be asking Mr. Arjun the next question. Mr. Arjun, are you still with me?
Yes, I'm here.
All right, thank you very much. So I would like to ask, do you think there are digital arbitration platforms or ecosystem abroad that have successfully connected professionals with actual arbitration work?
Yeah, I think there are quite a number of platforms in the market already, but I think there are more demand for such platform from all the countries, especially like if I talk about Africa, I think there is a need for such platform, and I believe especially Nigeria, if Nigeria aligns its digital arbitration ecosystem with global standards, I think it can position itself as a West Africa's dispute resolution hub in the coming future.
All right, thank you very much, Mr. Arjun. Thank you very much.
Thank you.
All right, Mr. Folarin, are you with me?
Yes, please.
All right, thank you very much. So my next question to you is, for young lawyers trying to find their footing in arbitration or intellectual property related ADR, what practical entry routes do you think exist here in Nigeria?
Well, that's another fantastic question. It's like you definitely came prepared. I think the biggest challenge is dispute resolution. So we say that there's an access to justice problem in Nigeria. And what you find is that the public don't have access to, we don't have sufficient outlets, that will provide access to speedy, timely, and efficient justice for members of the public. And so what you find is that people they look for ways and means through which they can achieve this justice. That's why Hembelembe, may be more popular than the courts, or people may view it as a more effective platform, or VDM, for example. And these are social realities, or any of these other so-called influencers. Now, many of them actually use some kind of social shaming. They go about the process of achieving justice perhaps the wrong way. But the question is, there clearly is a huge demand for justice. And I would say on the flip side of that coin also, you find that you have many lawyers with access to this speedy justice or some form of, speedy resolution, whatever issues or disputes that they have. But then the question is, what are the institutions in place? What are the platforms? And I find that to a large extent, some of these platforms, some people might argue that, we don't have enough platforms. So, and I would agree with that to a large extent. I did some research a few years ago on the adoption of ADR, arbitration, mediation, negotiation, conciliation in different countries, including India. Interestingly, India has a very similar history or trajectory to ours, because they're a common law country, former British colony, and the adoption of ADR has also been as slow and as difficult, perhaps as ours has been. But you find that many lawyers, I don't think there are enough platforms for expression for lawyers. And I think particularly young lawyers, my advice would be, like I said, the first thing should be specialized. because in ADR or with ADR makes it difficult to be a general practitioner, because now you go into issues that deal with, in order to achieve speed and actual justice, you must be familiar and conversant with the nuances of whatever area that dispute is being resolved in. So specialization is very key. That's number one. Then number two, I would say that I think we're finding them. I think IP Institute has a platform, but people are building platforms to lawyers to actually give life to some of these, to help their clients resolve disputes. And I think that is very, very, very key. And that's one of the areas that I think All Arbitrate really is doing a fantastic job. There are some other platforms too that seek to provide forums, for lawyers to express themselves and to help their clients resolve their disputes. So I would say, number one, specialize. Number two, key into any of these forums. Now, with regards to IP, I had mentioned that the ePlan will have a clinic. The ePlan is available on social media, on LinkedIn, Instagram, Twitter, Facebook. But ePlan has a clinic. And that clinic we try to provide some form of expression to lawyers, especially to IP lawyers, particularly with regards to IP lawyers who want to gain some form of experience, or lawyers who think, oh, I might be interested in this area. I would like to gain practical experience, but I don't have any briefs, So what that does is it provides practical, pragmatic experience for our clinicians. In the same way too, at the IP Institute, we also have similar formats. In fact, we have a mediation program, which on the sidelines of this conversation, I'll be talking to Mr. Dingy about. But the idea is that there is definitely a need for us to adopt faster means of resolving disputes that don't necessarily need to end up litigation, particularly with regards to disputes that emanate from contemporary issues. So you look at e-commerce transactions. Two people do a transaction online. They're not looking to spend weeks and months reporting to EFCC or reporting to Zone 2 or to SARS, or showing up in court, dragging one another up and down. A speedy resolution saves everybody. Look at the entertainment industry that is going. We have this. What show was it the other day that has been engulfed in a copyright dispute? And because of that, even though Netflix has paid the money for a second season, we've not gotten a second season yet. So with regards to new technology, new media, and modern business needs very speedy resolution processes that help both parties exit as friends and that allow people to make money as opposed to making enemies. So I would advise young lawyers to embrace these new platforms, embrace specialization, and sign up to any platform that allows you to express yourself, and give a voice to your clients, because I think that is very key. Lagos Consular Court has done a fantastic job in that area. I think Lagos State has been at the forefront of, in terms of the stage now, of advancing the development in this area. But I see FCT coming up as well, and I see a lot of private arrangements, such as the allarbitrate.com. So that would be my advice to young lawyers in brief.
Thank you very much, Mr. Aluko. That was really, really insightful. Thank you for the practical breakdown. Also, thank you, Mr. Shetri, for your time and for your thoughtful response. Thank you very much. Thank you for being here. Okay, so that will bring me to the end of this particular segment. But before I proceed to the next segment, if you have any question for Mr. Shetri and Mr. Aluko, you can please drop it in the chat box and I'll address that shortly. Thank you very much. Okay, so moving on to the third panel, which will focus, rather the third panel session, which will focus on technological shifts in the provision of legal services and how it affects our earning power as professionals. Joining us for this session are distinguished experts, Mrs. Temitope Johanna and Mr. Kayode Adeniji. You're welcome, and thank you for being here with us.
Thank you for having me.
You're welcome, sir. Mrs. Temitope Johanna, are you here with us, ma?
Yes, thank you for having me.
You're welcome, ma. Good to have you here too.
Thank you.
All right, so let's get right into it so we don't waste any more time. To Mrs. Can you hear me?
Hello, Amalabake.
I can hear you, sir.
Yes, do you mind if I may just make a very quick public service announcement?
All right. All right. Please go ahead, sir.
The link for CPD points. Sorry, I'm wearing my CLE committee chair cap. The link for CPD points is in the chat. So we encourage everyone to look at the chats and fill out the link for CPD points so you can get your CPD points. The link expires in 10 minutes, please. Thank you. Thank you, Labake.
Thank you very much. You're welcome, sir. All right, Mrs. Johanna. Good to have you here.
Thank you.
You're welcome, ma'am. Okay, so my very first question to you, from a corporate perspective, what do companies like yours look for when choosing between litigation and arbitration?
Thank you very much. I'd like to say thank you to everyone here, to the organizers, to my fellow colleagues, and all colleagues at the bar. Yeah, firstly, to understand what companies like mine would look for, you'd like to understand the fast-paced business environment right now. And like we all know that regulation, trunks behind creativity and innovation. So regulation is usually trying to catch up. So, sorry, organizations. I work in a fintech, in the fintech space. I've been there for a long time, and most of my career, I've worked with companies who are in the forefront of innovation. What really marks dispute regulation? Sorry, dispute resolution. What are the deciding factors? The company would like to see some level of creativity in how much are you able to solve my problem and within the shortest possible time. Sorry, give me a minute. All right, thank you very much. So like I was saying, organizations are really concerned about um, time time management. The biggest factor is how can I solve this issue with the least resources and with the least amount of time. So, of course, arbitration is always most preferred by organizations like mine. Why? Because the traditional court system, I would say, has lagged behind. I beg to say this, but sometimes when you listen to the traditional practitioners, they also seem to be catching up with the new products, with the innovations and all that. And so I've seen cases where disputes have dragged on. I'll use an example. Um, I worked in an organization about 10 years ago, and there was an issue. We had taken a property, and there was an issue around whose agent was who, you know. Of course, even though I'm not in active legal practice, of course, you don't want to um, lag behind when advising the company. So I was very certain that the claims from the other party were going to fail, and I actually did suggest to this party and say, "Hey, don't let's waste our time dragging ourselves to court. You're going to spend time and money." But the person was very adamant I left the organization after 5 years. Do you know that it was after that time that the external counsel called me and said, hey, do you know that that case, it was ruled in our favor? Now look at the time spent, look at the resources spent, and the fact that the other party was obviously on the wrong side of the law and was not properly informed, and we had lawyers on their side who were saying, hey, we'll beat them in court, wrongly advising their clients. These are things that I, as an in-house counsel, have related with quite a lot of traditional practitioners. And when I say traditional, I'm saying the regular, law firms and all that. And I discovered that there's a lot of textbook approach with relating with or to solve disputes. So for me, for any in-house counsel, what we look at creativity, we look at speed, we look at costs. Those are like the major factors that decide what dispute resolution mechanisms would employ in any contract dispute. Thank you. I hope that was extensive enough for you. If you have additional questions, I'm happy to answer them.
Thank you very much, Mrs. Johanna. Thank you very much. Even though I was itching to know who the name of the other party is, based on the principle of confidentiality, you can't let us know. Well, it's fine. It's fine. All right. So my second question to you is that, are you open to using virtual or online ADR platforms to resolve disputes, especially where maybe time and efficiency are key?
Without need to say, that's a big yes. I mean, the world right now wants justice, food, every service at their fingertips. So if things like ADR, is at my fingertips, I mean, nobody would be adverse to employing that. So without further say, yes. You have a follow-up question to that? I'm happy to answer.
I do. Thank you very much for that, Ma. Yeah, that yes was so personal. I could feel it from here. All right. So, Ma, what kind of skills or digital competence do you now expect from external counsels that are handling tech-related disputes?
Okay. First of all, I would like it's not really about the tools, it's about the skills, it's about your approach. It's about right now you don't even need to go to school to be able to use all that's at our disposal. I think right now the problem in the world is there's even too much information, there's too much data out there. So what we're looking at, or what I would like to see, is creativity. What I'd like to see is how much are you matching up with innovation. For example, the use of AI. I mean, whether we like it or not, it's come to stay. I would like to see a lawyer who is able to leverage, because even though we do say AI has come to stay, the honest truth is, with my interaction with the use of whatever AI services I've used, I still find that there's the human factor. You can't remove that. What I'd like to see is teams who are able to build something very efficient using tools like artificial intelligence.
All right. Thank you very much, Mrs. Johanna. That was really, really insightful. Thank you very much. All right. Moving on, I'll be asking Mr. Kayode Adiniji some questions. Mr. Kayode Adiniji, are you with us?
Yes, I'm with you.
All right. Thank you very much. Okay. So my first question to you is, okay, we've heard a lot about barriers to entry. I mean, I'm a young lawyer. Barrier to entry, limited access, few opportunities, and even lack of structured exposure. So if we could create a secure digital environment where lawyers can test their skills, maybe get listed, and maybe participate in real ADR cases, would that help address these gaps?
No, okay. Thank you for the question. I want to say thank you, MBSLE, and my Lord Justice Nipo Kanu and Chairman Emeritus of the MBA. I really want to thank everyone for this opportunity. First of all, from what you have said, I would like to say to everyone, and what my Lord has said in his paper hit me very hard, that if we do not embrace this, we are going to be left behind. So for us, or for me, I participated in the Airtel arbitration between 2012 to 2016 when I was head of litigation in Honeywell. And I felt at that time that, and it formed my opinion of arbitration, because at that time, ADR seemed like a simultaneous equation that a lot of lawyers don't like mathematics. But I realized, and this is my definition of arbitration, arbitration is a privately organized litigation. Because when they give us some of this definition, it confuses us. So what the world is saying is, if I am in Japan and I am investing into Nigeria, into Omolabake's business, and I am in Japan, I have given you money, hoping that that business will give me profit. If Omolabake handled the business in such a way that I don't like, what happens in traditional litigation and arbitration is that I will come over to Nigeria, I will sue Omolabake to court, hoping to get justice. Then there was a creativity, and the entire world, the New York Convention, then says, no, instead of Kayode, who is in Japan, to come to Nigeria to file a case against Omolabake in Abuja High Court or Lagos State, because I'm in Japan, I don't know the system of your country. I will have to maybe come to your country, look for a lawyer to be able to file and enforce my right against you. Rather than that, what I will do is that Kayode will be in Japan. It will come, so traditional arbitration means Kayode will be in Japan. It will look for an arbitrator, maybe a Japanese. Omolabake will appoint our own arbitrator in Nigerian, and those two arbitrators in a three-man panel will then choose a chairman who must be maybe not a Nigerian, or it could be a Nigerian, but both of them must be confident that that neutral person is indeed neutral. But what we have done is to say, instead of Kayode to come from Japan to have an arbitration proceedings in maybe a hotel, which is that's the practice. You choose a particular venue. We will have to pay for hotel. We will have to pay for the cost of the fees of the three arbitrators. We will then have to pay for our individual lawyers. That's a lot of money. That's very expensive. I'm going to factor in flights. But what you have created is to say, Kayode is in Japan, Omolabake is in Nigeria, and I want to enforce my right. I go on the computer, on a platform, look for a lawyer in Nigeria and say, I have read the profile of this lawyer. I think I like him. I have gone outside of this platform and I have searched him, maybe LinkedIn, and I've seen that he has been consistent and is somebody that can handle my case. I appoint him on the platform. And when it is time for me, I file my case on the platform. I'm in Japan. I'm not taking any flight. I put all my documents together with my lawyer. I call him on the phone. He prepares the document. And on the platform, he uploads my document. When all of that is done, a signal is sent to Omolabake in Nigeria, to our email, to say, Kayode from Japan has a matter against you. Omolabake sees that. And she also have a lawyer. And then she files in response to that. Arbitrators are appointed. And everything will be done online within months, even weeks. With that, what we have right now in Nigeria is we have a lot of lawyers who have arbitration certificates, who have mediation certificates, but we have not been given a chance to at least witness one ADR proceeding from the beginning till the end. And then different institutions train us we pay a lot of money. I paid up to over 200,000. It was even subsidized at that time in 2013 and then they give us the suffixes to our name, MCRAB, and then we never have the opportunity. So what we want to do for young lawyers is to say, yes, you go for training, you get certified, but that certification and training is not for decoration. It is for you to be able to use it to solve people's problems and then make money. And the kind of money we are making is not the kind of money where clients are in court for 3 years and you are collecting money for transportation and appearance allowance. It is a kind of money you earn. By the time you finish a particular case within 2 months, you move to another one. And in 1 year, by the time you look at your account on the platform, by the time you look at your account, you see that I'm doing something with my life as a professional. So that is the kind of future we have created with what we have done. If you are a lawyer, you have moved to the UK and you do not have the license to practice in the UK, you can still be in the UK and be running arbitration proceedings back in Nigeria. You can travel to anywhere in the world and be appointed as a lawyer or an arbitrator or in mediation from any part of the world. Your clients do not need to be in Nigeria alone. So if you're able to do that, young people who from law school have gotten their mediation certificates from maybe Lagos Multi-Door Court, Nigerian Institute of Child Arbitrators or Child Arbitrators UK branch, you can then use your skill to learn from experienced arbitrators who are conducting a case. They can also appoint you and press a button and say, you know what? I have been appointed the chairman of these arbitral proceedings. You are just fresh from law school. Join me in these arbitration proceedings and be a secretary. We'll pay you an amount of money. With that, you are growing your experience on the platform and everybody is okay. So that's the kind of future we're looking at. And I think that the future is already here. It is just in our hands to embrace it or reject it.
Thank you very much, Mr. Aniniji, for that thoughtful contribution. And then that leads us perfectly to the next question I need to ask you. Okay, I see with me, sir?
Yes.
All right, thank you. Okay, so for those who want to take the next step, I mean, what's one thing they can do immediately after this session? So maybe position themselves for the future of dispute resolution.
I think I have I'm just going to, the next step for anyone is to, number one, we can create arbitration briefs for ourselves. We do not need anyone to call us into an arbitration proceedings. And I'm saying this with every sense of responsibility. As a lawyer, as an arbitrator or a mediator, you do not need anyone to invite you to an arbitration proceedings. You can create it with your hands. And one of the ways to create it is to ensure that every agreement that is being drafted as a lawyer, the first thing that should be on our mind is to say it is a commercial agreement, is to say this should be, every dispute arising from this transaction should be settled by arbitration. You then decide, what platforms do I want to use? Do I want to use the traditional platform where I have to write to the judge to appoint an arbitrator for us? And that is, we are adding to the workload of our judges. Or do I just want to say, on this digital platform, this is where we're going to go. And the rules on that platform is what will apply so that we can settle our dispute on time. So you do not need anyone to invite you. It is from all the contracts you have been drafting for people. Obviously, you know the matters that are not arbitrable. This is not a training for arbitration. It is to show us the commercial, the financial side of arbitration and technology for us to move forward as a people and as a profession. So every contract as long as it is not criminal, you can't arbitrate on criminal matters or ownership of property. But tenancy agreements, loan agreements, IP agreements, employment contracts, these are commercial transactions that should be settled through ADR, arbitration or mediation. The second thing we need to do is to get certified and trained in the art of arbitration and mediation. And this thing is it is simple, but most of us see arbitration as a special area of law where that the practitioners are special people. No, I have participated in very complex commercial arbitration, and I have seen the way it plays out with UK lawyers, with American lawyers, with SANs and all of that. It is to ensure that parties get justice. As long as you're not coming with the courtroom mannerism or mentality. Everybody sit down in a hotel in one of the meeting rooms with, UK people, American lawyers, South African lawyers, and we all agree on, this is the rule, these are the documentation, and everybody looks at the document. Even cross-examination, you sit across the table and you're asking people questions. It's not about shouting or somebody standing in the witness box or the docs. People come together. So it is a privately organized litigation. That's my own definition of it. So if you get certified and get trained, we can start having this revolution that my Lord Justice Bukano has mentioned, and what Mr. Aluko has mentioned, and from what Mrs. Joanna has said about what they need from lawyers. This is where we start from. I do not want to waste my professional life and time attending to a case for 3 years when I can cover 10 cases within 2 years and earn money. And that is how I think we should start. I want to conclude with this. The market size of arbitration. The International Chamber of Commerce, ICC, they released their full dispute resolution statistics in 2024. And they said that 841 new arbitration cases were filed in 2024. And 831 under the ICC arbitration rules, and 1,789 cases pending at the end of the year. That is ICC, meaning, and these cases are big ticket cases. Let me tell you another point. The total amount in dispute across all these cases reached $102 billion, while the value of pending cases hit a record of $354 billion. These are arbitrations that will involve, international companies. But within Nigeria, there is a market for arbitration. People who look at a dispute and they just think about how long they are going to spend in court, and they just decide, you know what, I'll leave it. I have that case about last month. Somebody is owing somebody I met who is owing him 15 million. And he's saying this person doesn't want to pay me. A commercial transaction, but because there was no agreement, he heard about all arbitrate. And I told him, he said, how can I come on? I said, but you need the consent of that person to come, because if you have had an agreement from the beginning, you will not be in this kind of situation. And the party owing him was ready. He said, go to police, go to EFCC, we'll meet you there, because that is the normal practice. And those people know that it will drag. After all, federal government is owing, every government is owing. You can't kill me. But if there were arbitration clauses in agreement, in loan agreement and all of these things, we will go to arbitration. We will pay for the cost of arbitration and you will get your judgment. Every arbitration agreement is enforceable by our Arbitration and Mediation Act. So this is the way to go. Thank you.
Thank you very much, Mr. Adeniji. Thank you very much for opening my eyes. And I believe that I speak for everyone here that you have opened our eyes to see that arbitration is not only for the elite, it can also be for the common man. Thank you very much, sir. All right, moving on. So I believe that what we've learned today is that opportunity in ADR is no longer limited to geography or hierarchy. The next frontier is access, and platforms that connect qualified lawyers to real dispute rather, are leading that change. So our goal is to make sure that you are ready when that opportunity arrives. So if you found this conversation really helpful, I would like to tap into the future of arbitration and mediation. At least I know I want to. You can visit All Arbitrates at www.allarbitrates.com for more information on how to onboard. But before that, I'll be doing a run through on how to onboard on the All Arbitrate platform. Can I please have the slides? Okay, thank you very much. Okay, next slide, please. Okay, so as a professional or as an individual or as a company, the first step is to create your account by visiting www.allarbitrates.com. After which you click Get Started, and then you register either as an individual, as a company, or as a professional, that's an arbitrator, a mediator, a legal counsel, or as all of them. So next slide, please. Next slide. Okay, so after you've done that, you can then confirm your email. That's step 2. Then you add your basic details like your name, your contact, your area of interest, etc. After which you upload any required personal information or business info. So next slide, please. Okay, so step 3 is to submit or respond to a dispute. Now, first is to log into your dashboard. This is as an individual now. Then you click Initiate Arbitration. Then the next thing you do is to provide case details and evidence. After which you choose preferred resolution type. Is it an arbitration or is it a mediation? Next slide. Okay, step 4 is resolution process. So an arbitrator or mediator or legal counsel is appointed. Then the pre-hearing and hearing virtual session. Then a secure chat and document exchange. And then the final award is issued digitally. So step 5, case closed. So you get your downloadable award. You download or print anytime you like, and then you rate your experience. So it is very, very seamless. Very, very seamless. Okay, so join the feature of dispute resolution today. Visit www.allarbitrates.com. You can also download the All Arbitrate app. That's for professionals. That's for arbitrators, mediators, or lawyers. You can just download it from Google Play Store or Apple Store to get started. Thank you. All right, so on that note, we officially bring this webinar to a close. Thank you very much to our panelists, my Lord, Honorable Justice Adini Ipokanu, Mrs. Temitope Yohana, Mr. Arjun Shetri, Mr. Kayode Adiniji, and Mr. Folarin Aluku. Thank you for sharing your time, expertise, and perspective with us today. Thank you very, very much. Also to our wonderful audience. Yes, thank you very much. So our wonderful audience, thank you for your attention and engagement. I mean, we hope you gained valuable insight to take back with you today. I really do hope, because I did. All right, my name is Omolabake Uhu. and do have a lovely evening. Good night, everybody.
Thank you, Omolabake. Good night.
Night.
Thank you very much. But very, very quickly, I think this conversation should not end here. Maybe, of course, you know where to find my Lord Justice Pukanu. I'm on a group where my Lord's first list was posted this morning, and I said the people don't know that I'll be with my Lord virtually later in the evening. So we know where to find my Lord. But maybe we could also share. Yes, my Lord. We could share details about where to find the other speakers. I'm sure my Lord is also on LinkedIn. My Lord is very tech savvy. So we're all on LinkedIn. Let's take this conversation forward. It shouldn't end here. How do we engage? The ideas. In fact, my Lord dropped so much on the table. I think we should have a part 2 of this sometime, because I could see that my Lord was making references. He didn't want to go into the nitty-gritty, so there's clearly so much more. But I know that we can find everyone on LinkedIn and on other forms of social media, so we can take this forward. Maybe we can share LinkedIn profiles, perhaps. Yes, something.
And I also read questions from participants asking for my Lord's presentation, because he quoted a particular case that people would like to have. I will also share the slide of what I was able to. Yes. So we'll make it available for people. And my Lord, I really want to thank you. It is just my own desire that we as Black people in Nigeria will lead this revolution. We do not wait for any Caucasian or developed country to do something for us to now copy. I'm very passionate about it, my Lord. And we would like us to solve our own problems with our own brains, whether we make mistake or not. If we succeed, other African nations will follow us. If we fail, we will see what we have done, how we have improved our own justice system. We're just hoping that with this, if we can lift from the court all the commercial backlogs of cases, my Lord will be able to have the time, the freedom of time to be able to attend to cases that have to do with the real justice of the society, the congestion in our prisons. Because, for example, I don't see the reason why matrimonial matters will still be sitting in some of our courts. It's a private matter, and we still have criminal cases and people in prison, and then we go there to say, oh, we pardon all of them. We can attend to their cases faster if my own case between myself and my wife can go to arbitration, if my own case between my business partner can go to arbitration through technology. I really want to thank you, sir, for your insightful talk today. It is really, really exciting to know that the bench and the Lagos is leading the way for all of us to follow. Thank you very much, my Lord.
Thank you very much.
Thank you, Mr. Adelenji. I could see some hands raised earlier. Does anybody have any question for any of our panelists? You can spare 5 to 7 minutes. Any question, you can please raise your hand. Okay, I believe there is none, if I'm not mistaken. All right, in the absence of none, good night, everybody. Do have a lovely evening.
Good night, everyone. My Lord, good night. Thank
Yes,
you very
good night,
much, everyone.
Thank you.